new California laws that we have. There's quite a few of them today that we're going to go through, and lots to talk about. I do have an interest in your feedback throughout the presentation, so I definitely encourage using the question box to let us know what questions you have. I think they're a little more relevant if we take them as we go along. If you'd prefer to do it at the end, I'll stick around online as long as I need to answer any questions as well. There was an early question that came before the presentation began. I'd like to address that one first before we get deep into this. I think it's a really great question, and it's relevant to a lot of what we're going to be talking about today. So the question is, considering the recent uptick in activity in both state enforcement, DLSE activity, and federal activity, ICE and those sorts of raids, what action should we take if various regulators show up at the doorstep? That's a great question, and in my experience, I've seen that happen very regularly. In fact, the state labor commissioner, the DLSE, are a little bit notorious in my mind for sending a letter out and making it seem like it's just an interview or kind of a meet and greet thing, and then they show up and they want to see every personnel record and every time record and all of that. So the regulators, federal and state regulators, they definitely have the right to ask to enter your premises and to review your records. But you also have rights, and you have the right to be represented by counsel. And so typically a letter or someone just showing up at your place of business, if they do not have a subpoena or some order from the court, then they do not have any right to enter your premises. And you can simply say to them, we're not prepared for this, and we'd like to have you talk to our attorney first. That's what I would typically recommend, because a lot of times, if there's no subpoena or court order, there's a lot of things that we can do with sending records and just general conversations with the regulator before they ever have to come on the premises or interrupt the workspace. So that's my recommendation. If someone just shows up without any official form, and if for example they do send a letter or even a subpoena, I would recommend getting that to your attorney immediately, because the attorney can contact the regulator and oftentimes can work things out very without any interviews and without any on-site investigation at all. Most of the time, these regulators are looking for records and analysis and an assessment of some sort about whether there's compliance with the laws that they oversee. So that can be done in a very cooperative way, and quite frankly, often they prefer to receive things via mail and or electronically now, rather than doing the on-site location investigation. They are oftentimes overworked already and have a number of cases. And what I've found is, if you can demonstrate that you have legal counsel who's competent, who's helping you out, they will oftentimes rely on an assessment that's done by legal counsel, and will certainly try to help make sure that that process works smoothly. So that's the recommendation. Of course, if they have an order and they have a right to enter the premises, then you can't, it wouldn't be wise to stop them. But most of the time they do not, and I would recommend getting your attorney involved. All right, I think that answers that question. And let me just move that question down so that we can see if there's any other questions. Like I said, I appreciate people who ask questions. I prefer that to just going through the presentation, but let's get moving here now. All right. So this is the agenda for the day. Like I said, there's a lot here to cover, and but I want to give you an overview of what we intend to do. The wage and hour issues are many, and we'll talk about those. And we'll just walk right down that list. I'll try to get through everything. 1 hour is not a lot of time, but as you have questions, just let me know. These are all of the areas that I think we have new laws or interesting new analysis that's worth discussion. All right, getting started in the wage and hour area. First thing for California employers is, of course, each year now the minimum wage is increasing. And you see there on the slide that effective January 1, everybody's going up to at least $10.50 an hour. If you have more than 25 employees, you're going up to $11 an hour. That also is going to impact some of the salary exempt employee salaries. In California, the minimum salary that an exempt employee can be paid is 2 times the minimum wage. So each year that the minimum wage goes up, the exempt employee minimum salary will also go up to the same percentage. You'll also note that by the in January 1, 2023, we're going to be at $15 an hour. And then after that, there's a process that they will use to increase based on some indices that they have designated. So each year, you should be ready for that increase. Next, in the wage and hour area, over the last couple of years, we've seen a big uptick in wage discrimination legislation and then the corresponding litigation as well. So back in 2015, the Equal Pay Act was amended in the state of California. Now, it has been illegal to pay men and women differently since the 1960s, actually, when when Title VII was passed. So this is not a new concept, but it is getting renewed emphasis. And I think that comes from the fact that statistically, men are paid higher than women across the board. And so I think that for as long as that inequality continues, the law is going to try to figure out how to make that right. So in 2015, we had this move that was an effort to try to make sure that wages were not being based on gender. And there's been, back in 2017 and now again in 2018, there's additional modifications to that law. The most recent one simply expands the definition of employer, so that is not a significant change for most of us. However, I think it's important to touch on this because to me it shows a trend in wage disparity based on gender. Any other protected classification would also be inappropriate to pay people on a discriminatory basis because of race or religion or any of the other protected classifications. But gender has been given kind of a higher priority, I think. And it behooves a good employer, I believe, to take a little bit of time and make sure that the processes that they are using for determining compensation do not have any gender biases in them. because this is an area that I think is going to continue to receive emphasis from the law. And we see that here in this new law. This is a law that is aimed at making sure that prior discrepancies don't get continued and move forward in the employment process. So what is being prohibited here is an employer asking about or relying on a prior salary history. So many of you are in hiring and understand this, but one of the questions that has previously been appropriate and legal is just to simply ask, what are you making right now, or what did you make at your last place of employment? What is your compensation history? And this law prohibits us from asking that question any longer. The idea being that we don't want to just continue forward the past history, and we should be paying people on more of a merit-based system within our own company and organization. Now, an employee or an applicant for employment can state what their salary history is, or state what their salary needs are. And an employer in the hiring process can ask, what are your salary expectations, or what are your salary needs? That's not illegal, but we cannot ask in our applications or in our interviews, we cannot ask, what is your salary history? That's really what's being prohibited here. So that may require some changes in our interviewing process. You may want to look at your applications and make sure that we're not asking for a salary history. You can certainly ask for employment history, like who are your past employers and things like that. You can still check references and things of that nature, but we can't ask about the actual salary history any longer. Next, in the wage and hour area is just really a reminder. So in the labor code, there are a number of provisions that deal with the pay stub itself. And there's certain information that needs to be on that pay stub. What we've found over the last several years since this law has been in play is that it's very technical, and if you miss even the name of the company as wrong or some other piece of information, there's about 7 or 8 pieces that need to be on there. If you miss any of them, then you're subject to a civil penalty, and that civil penalty is not necessarily onerous when it's just one, but usually if you're making a mistake in a pay stub, then it can grow very easily to a significant penalty. In order to receive that penalty, under, you see here, Labor Code Section 226, there is an obligation for the employee to show that they've somehow been harmed and that there was a knowing and an intentional failure by the employer. But this recent case, in the Lopez case there that you see, it's referring to PAGA, which is the Private Attorney General's Act. And that PAGA claim, which is a representative claim, does not have the same obligation to show that there's been injury or that it was because of the employer's knowing and intentional failure. So PAGA claims, this Private Attorney General Act claim, is quite common now. It's representative in nature, meaning that a single employee can bring it on behalf of the entire workforce. And because there now is a lower threshold, lower standard when you bring it as a PAGA claim, it makes these claims much more likely and much easier to prove. And attorneys, plaintiffs' attorneys, bring these PAGA claims on a regular basis. So the point here is to check very carefully your pay stub. Go through an internal audit. Make sure that on your pay stubs you're covering all of the items that need to be covered and that it's all accurate and properly on the pay stub. Because these are kind of silly claims that can be brought, but they can be costly when they're brought on behalf of all of the employees. Next in the wage and hour is this case, Mendoza v. Nordstrom. And this deals with an issue that doesn't come up too often, but it is under the labor code. There is a provision that says that employees can't be worked 7 days in a row, that they are entitled to, guaranteed to, 1 day's rest in 7. And so this case looked deeply into that statute, which hasn't received a lot of attention in the past. And what we find from as a result of this case is what you see here in the bottom 3 bullet points. And essentially, as an employer, we can offer up a 7th day of work. And if someone wants to take that, usually it's going to be overtime. So there's that premium that's placed on this work anyway. But we can't force people to work on a 7th consecutive day. And the bottom point there is an important one. It's 7 days in the same work week. It's not a rolling 7 consecutive days. So if your work week is Monday through Sunday, then you could have someone work 4 days in a row during one work week and 3 days in a row in the next work week, and you would not be in violation of this labor code provision. But if you can't have someone then work Monday through Sunday, you could do, Wednesday, Thursday, Friday, Saturday, Sunday of one week, and then Monday, Tuesday the next week, because it's not falling within the same work week. So that's a benefit, that's a plus to an employer. But a recognition that the 7th day type of rest under the labor code is going to be enforced. It can be helpful to understand when you're scheduling employees and making sure that you're not scheduling them 7 days in a row unless they voluntarily want to do that. This too is just a bit of a reminder. It's an interesting case. It deals with commute time, which is this going and coming rule. And essentially what it says is that employers are not liable. It's not work time. It's not compensable when you're commuting to and from work. However, if an employer does put someone on a special errand and say, on your way home, please go do this task at my direction, then they are within our control. That is compensable. And we do have an obligation to pay them and reimburse them for their expenses. That's the general rule that I think is important to remember. This particular case, the Genentech case there at the bottom, indicates that a supervisor can't change his or her commute time into travel and compensable time simply by giving himself or herself a direction and telling himself or herself as a supervisor that they're going to go on a separate task. So it's a little bit of an odd case, but it's important to remember that whenever our employees are within our control, whether they're commuting or doing anything else in their off hours, if we bring them under our control, then it becomes compensable. And the hours worked issue is becoming more and more significant in California. You find that people now have cell phones, they have email access. Supervisors are asking people to do things in on off hours, And because of that, you can have a compensability issue that needs to be addressed. All right, I see another question here. Let's do that. Okay, great question. Consistent with what we're talking about here, going back to the 7th day, I think, issue. So the question is, can you work 10 days in a row, 5 days in the first work week, then on the next work week, Monday, Tuesday, Wednesday, Thursday? And the answer to that question is yes, you could. You could do that. That's what, let's see if I can just go back to my previous slide here. Yeah, so if you look at this, the final bullet point or check mark there, 7 days is to be calculated on a per work week basis and not a rolling 7 consecutive day basis. So in the scenario that the questioner asks, that would be on a rolling 7 consecutive day basis, you would be in violation. But that's not how it's calculated. It's calculated on a work week by work week basis. So in this particular situation that's been asked, the Monday, Thursday, Friday, Saturday, Sunday would be 5 days in that work week, and they would have gotten the 2 days, the Monday and Tuesday off for that work week, so there'd be no violation. And then when they come to work and work Monday, the next work week, and work Monday, Tuesday, Wednesday, Thursday, Friday, then they've got 5 days, but they're going to get, I'm presuming, Saturday and Sunday off, so that's their 2 days off there. So the answer to the question is that you could do that and there would be no violation. All right, looks like we have another question. Let me pull that up. Thank you again for your question. With no overtime, yeah, depending on there would be no weekly overtime, depending on the schedule. If 40 hours in the first work week, 40 hours in the second work week, there would be no overtime. That is exactly correct. If you had some daily overtime, that might be a separate question, but no weekly overtime there at all. It's correct. All right, so very good. Thank you for those questions. That finishes up our wage and hour discussion. And now let's move to another area that is significant. We'll try to keep moving here because I see that our clock is already ticking. But so employment discrimination, prohibited harassment, this is obviously a huge area. Most of our wrongful termination types of cases are in this area. The protected classifications that I'm sure we're all familiar with are continue to be, I think, the primary area of labor and employment law. And making sure that you understand how this works is critical, I think, to avoiding litigation, which is what we're all after here. So the first one that we want to talk about is this new law, AB 1008. This has been called Ban the Box. It is a ban on criminal background history inquiries. And this goes back to our application process that we were talking about before in the wage and hour area and the gender disparity and the salary history. Now there's some limitations on when you can do a criminal background check on folks. And we've always had some regulation here because this is an invasion of privacy. And invasion of privacy requires a balancing test. And so pre-employment background checks have always had certain checklists that we needed to go through, and most of these are done through a third party. Typically there's a service that will provide that, and they usually know these regulations well, and they give the disclosures and the notices, and they're all fine and taken care of. What this new law says, though, is that timing matters. So with regard to doing a background check pre-employment, the law says from now on we are not going to be able to do that until we have given a conditional offer of employment. Now, in some regards, this is not going to change practice because most employers because the criminal background check costs money from the employer. You have to pay for it. A lot of employers have always waited until after there was an offer of employment before they would do a criminal background check. So oftentimes you do conditional offer of employment and then do your drug testing and your criminal background testing, because that you didn't want to do that for all applicants. The additional piece, though, that is important here is not just the timing. So now we have to, by law, do the criminal background check after we've made a conditional offer of employment, which is very similar to drug testing. So a lot of us have had to deal with that before. But also now there's a process that needs to be followed and an individual assessment. So just because a criminal background check comes back saying that there is a felony or some type of criminal history here, we cannot simply just say, okay, then we're not hiring you. You must have a relevant basis for making the determination that you're not going to hire. So the conditional offer of employment is made, the criminal background check is conducted, and then if it comes back with a criminal history, we need to review that history and do an individual assessment to determine whether or not that criminal history has some relevance to the employment relationship that we are going to engage in. And if we don't find that connection, then we can't use the criminal background check to avoid the employment relationship. So not only is timing important, but now we need to have some reasonable basis, some reasonable connection between the history, the criminal history, and the employment relationship. So a good example, of course, would be if I'm a bank teller and my criminal history comes back that I am a thief of some sort of theft or fraud or something along those lines, then that would be relevant, and your individual assessment would be appropriate to say, I'm not going to hire this person. But if they come back with some sort of traffic violations, even serious traffic violations, and they're never going to drive for us, then I think you would have a harder time demonstrating that there's a reasonable basis between the criminal history and the employment that's going to be taken. So it's requiring us to take this next step, which is, one, make sure there's a conditional offer of employment first, and then two, make sure that there's a reasonable relationship between the criminal history and the employment that's going to be offered or given. Now, again, this too is not necessarily a significant change in practice. Our advice has always been to our clients that we should have a rational basis, kind of a reasonable relationship between the criminal history and the employment relationship. But now it's a hard and fast statute, and we would be in violation of the statute if we didn't comply. Looks like we have another question here. So the question is, how about looks where they have tattoos on their faces and we decide not to hire? Okay, that's a great question, and it does come up frequently. In general, dress and grooming types of standards are still legal and appropriate. From time to time, they do have an impact on some protected classifications. For example, if the tattoos had some religious significance or had ethnic or racial significance of some sort, that would be an area where we would be more concerned. But tattoos in and of themselves, without any other analysis or connection, are not a protected classification, and so it would be appropriate to make a determination. Now, an employment determination on that. Typically, what you want to do with any type of dress and grooming type of standard, appearance type of standard that you have, is to make sure that again, it's reasonably based on the work that's being done. So obviously there's safety issues in some dress and grooming standards. Certain jewelry when you don't want to use because you're around heavy equipment, certain grooming of the hair and things like that that make a lot of sense. So those kinds of standards are always going to be in play. But using this specific example, tattoos, maybe that's not the appearance that we want to give to the public. Okay, that's fine. But if it's a position that doesn't have any interaction or visual interaction with the public, then I think you'd have a harder time justifying that as a basis. Now, it's not a hard and fast rule, but what I'm saying is you have employment-related policies. And you want to make sure that they're connected to the employment relationship itself, because as you do things that have the appearance of being arbitrary or capricious, that then opens up the opportunity for someone to argue, well, maybe that's because of my protected classification in some other setting. So a good standard for dress and grooming is just to say we require a professional look while you're at our employ. And that's how we want to interact with customers. That's how we want to interact with clients. That's how we want to interact with our vendors. That's what we want to represent. And so in situations like that, sometimes employees are asked to cover up certain tattoos or wear certain types of clothing. That's all appropriate and correct. But be aware that there can be a connection between dress and grooming and some of the protected classifications. Religion is a big one, but others can come into play. And so we need to be careful. And again, I say that the best approach is to make sure that there's a reasonable basis between what we're expecting and what our policy is. Okay, it looks like there's another question here. Let me get down to it. Okay, hold on. I thought there might be another one here. Okay, so 2 examples. Would not hiring an applicant with a sexual assault conviction be discrimination, especially if you're worried about said employee making inappropriate comments to the customers? Great question. Yeah. I don't think that I don't think in and of itself it's going to be discriminatory. The question being, if I have some type of sexual assault conviction, is that going to be discrimination? What we would need to be able to do is to demonstrate that there's a connection between the two. Now, you make a good connection. The questioner makes an interesting connection saying, well, I'm concerned about inappropriate comments or inappropriate conduct that would be a violation of our prohibited harassment policy, for example, reading into this question a little bit. But I don't think that we could make that, I don't think that would be a close enough connection. Now, look, there's no cases on this. This is just an assessment and analysis based on the statute itself. But if we're looking for a reasonable connection, the fact that someone has an assault, even a sexual assault conviction, doesn't necessarily mean they're going to violate our prohibited harassment policy in and of itself. So I can't say for sure because there's no cases on it. But my assessment would be that would likely not be a close enough connection to be able to deny employment. Now, obviously, if there were any violation of the policy, that would be a reason for termination or discipline. And I think that a discussion about the criminal history that we've discovered and that we will not tolerate any of that, and if any of it happens, there will be a termination. I think all of that would be very appropriate. And I could see certain situations where you might, I think it would depend on the situation, the workplace itself. If it's an open workplace environment where there's not a lot of opportunity for one-on-one kinds of assaults, then that may be more difficult than if you've got to people going out into people's homes or different situations where you might have more one-on-one contact with other employees. I could see that possibly being a means of creating that reasonable relationship between the employment and the criminal history. But I think we have to ask those questions, and I think we have to tread carefully. It's not going to be a simple discussion any longer. Okay, looks like we might have gotten another question here. Let's just look. Okay. Let me just make sure I'm okay. Not sure if you talked about this already since I logged in late. Can I fire, and how would I fire if an employee is not happy or smiling with customers? Well, that's a good question too. I think that any disciplinary action needs to be based on legitimate business reasons, and the legitimate business reason that's being offered here is that the interaction with customers is not to our satisfaction. So if that were the basis for a termination decision, there would be nothing unlawful about that. You do want to look at how you use that policy and apply that policy across the board. So if we're only requiring the men to smile and we're not requiring the women to smile, then that would be a discriminatory act. But if we are across the board saying, look, everybody's got to treat customers with respect, and as you get any sorts of complaints from customers, then we're going to have to discipline you and even terminate you, that would be completely appropriate. I would, under those facts, it seems very appropriate to terminate an employment relationship. Okay.
Hey, Trevor.
Yeah.
Since we only got 20 minutes left, do we want to maybe hold off on the questions to the end so we can get a little bit further into your slides?
Jenna, thanks so much. Yeah, why don't we do that? I do like the questions, and I kind of prefer to answer them, but there may be folks who wanted to ask or learn about particular items. So let me go ahead and go through the slides a little more aggressively here, and then we'll take questions at the end. Thank you, Jenna, for that reminder. Appreciate it. All right, this ban on criminal background histories does in fact have some exceptions. You can see those there. They're not going to apply particular to our industry here, but they are available. Okay, there's obviously immigration is a significant issue for a lot of employers, and basically what this state law says is that we cannot open up our private workplace areas, our non-public workplace areas, to the federal government who might want to come in and do some type of raid or something along those lines, in investigation of some sort. We as employers cannot open up the private non-public areas of our workplace unless they have an actual warrant or subpoena, court order, something along those lines. So just generally speaking, an employer could voluntarily allow government agents into non-public areas if they consented to it, and there wouldn't need to be a warrant or a subpoena. This law is saying that we as employers in California cannot do that. We cannot consent. There needs to be a warrant or a court order. We'll have to see whether that plays out as far as constitutional rights and things of that nature, but that is currently the law. So the advice would be here to require, similar to what we talked about right at the beginning, to make sure that we're not letting governmental agents onto our property unless they have a warrant or a subpoena or court order of some sort, and not just voluntarily allowing them on. I think that's a good practice all the way around, but now it's legislated by the state of California. Similarly, this I think has aims at immigration types of issues, but it does it in a national origin discrimination type of an analysis, and simply says here that when we receive documentation that's consistent with federal law with regard to immigration status or ability to work in the United States, that we can't ask more questions. So federal law requires us, as you see there, to accept certain documents. We all know about the I-9 form and how that operates. What this law is aimed at is saying that you can't require more than federal law obligates you. So it really is an attempt to say, don't create a higher standard than federal law already has as you employ folks who might have a different immigration status. And I think the reason for, and they characterize that as a national origin type of discrimination. So the takeaway there is to definitely do the immigration reporting and review of documents like federal law requires, but be careful as you go beyond what federal law requires, and because that may be considered a national origin discrimination under state law. So both of these last two laws are aimed at the immigration population. Next is harassment training. The law says that if you have 50 or more employees, you have to do it every other year to your management staff and do this prohibited harassment training. What they've added now is that we need to specifically identify some scenarios that involve gender identity, gender expression, and sexual orientation. So this is not a new law. The prohibited harassment training has been on the books for quite a while. But it's an emphasis, it's a trend. It's showing that these newer classifications of gender identity, expression, and sexual orientation are meant to be taken seriously. They want us to train on them. And you can see a trend that those may be areas where we would see more litigation. So it behooves us to make sure that our policies and our practices are consistent with the law that prohibits harassment and discrimination against anyone because of their gender identity, expression, or sexual orientation. This is just a quick case. It had to do with a hotel, and the facts are quite kind of interesting, but I'll bypass those because of our time, and essentially say that the obligation to protect the workplace is not just associated with employees. It includes the protection of employees against third parties who come onto the property. In this particular situation, it was a customer who was sexually assaulting folks in the rooms, and that particular employer, the court determined, knew about it or should have known about it, and therefore they had an obligation to protect the employees and make sure that it didn't happen. So the takeaway here is to recognize that in all of our workplaces, it's not just about whether one employee is harassing another one, but whether customers are coming on and harassing, whether vendors are coming on and harassing. Visitors of any sort. We have an obligation to protect the workplace, not just protect from employees harassing one another. All right, next grouping is the leaves of absence, and we'll be able to walk through this. There's really just one law that I want to get to here. There's a number of different laws that are already in play, but one new one that we want to talk about. So as a precursor to that, the FMLA and the California Family Rights Act, which are kind of two state and federal laws that do the same thing. It gives 12 weeks of leave for your own medical issues as well as family members' medical issues, and some bonding time after the birth or adoption of a child. This applies to only employers who have 50 or more employees. But, and so a lot of us haven't had to deal with this because we don't have that many employees. Other leaves of absence are available. We'll walk through these quickly. There's medical leaves of absence under federal law, ADA, and state law. Pregnancy disability leave. There's no changes in these laws. These are the laws that have been around. Workers' compensation leave is also available. If someone has an injury on the job, they're entitled to certain leave. There's an obligation to try to work through all of these leave laws. So just because you're under FMLA doesn't mean you also might not be under ADA and might also be under workers' comp law. So there's a lot of different laws that come into play, and encourage you to make sure that your policies are such that you're complying with all those laws. Then there's a number of paid leaves that are available under California law. Of course, we know we have paid sick leave, vacation and PTO are closely associated with sick leave, as well as bereavement leave. These are paid leaves of absence. And then a whole host of other leaves that are available to employees: military leave, school discipline, voting, jury duty. These are all leaves of absence. They're not necessarily paid, but they are time that we need to make our employees available if they fall within these categories. Some of the more recent ones that are trending are domestic violence leave, which allows an employee to take time off when they are trying to protect themselves against domestic violence issues. That might be going to court, that might be going to counseling, and it's important to be aware that those are available, so that if an employee asks, you know that you have an obligation to give that leave. The last one here is the one that I wanted to get to with regard to leave laws, and that is this new Parental Leave Act. It goes back to the California Family Rights Act that we talked about before, which only applies to 50 employees. If you have 50 or more employees, this state law now says we're going to take a piece of that FMLA, CFRA obligation and require that those with 20 or more employees must provide 12 weeks. But this is just the bonding portion. When I say bonding, I mean after an adoption, after a birth of a child, an employee now has, in the state of California, a right to 12 weeks of unpaid leave, 12 weeks of unpaid leave to bond with that child. There's a lot of different requirements. If you have a husband and wife that are both in the same job or with the same employer, there's some limitations on this. But for the most part, these employees now, if you have 20 or more employees now, your employees have a right to, after the birth or placement for adoption of a child, to 12 weeks of unpaid leave, and they're guaranteed their job back. This can be quite onerous. It used to be for just employers with more than 50 employees. Now that it's down to 20, that can be quite onerous, and we're revising a lot of the handbooks that we do here to comply with that. So that's a new law. It's brand new, just in place this year, and we need to make sure that we're compliant with it. All right. That just goes back to say what we've already said, that the FMLA and the CFRA already cover that. For most folks, this is just for those who have fewer than 50 employees. Okay. And pregnancy, disability, and those sorts of things are still available to employees as well. All right, let's take a little bit of time here and talk about discipline action and termination of employment. Not a lot of new laws here, but just a good reminder of making sure that we do two things. One is to make sure that we don't violate our at-will employment relationship. And two is to make sure that we always have a legitimate business reason for any termination or disciplinary action that we take. Those are kind of the two takeaways from this section. Now, this is a new law that says that the Labor Commissioner, the Division of Labor Standards Enforcement, that they can, of their own accord, if they see any kind of retaliatory action against an employee, they can move on it. That's fine. This is not a change in the substantive law. It's always been against the law to retaliate against someone because they complain about their wages. This is just offering the Labor Commissioner an opportunity to act of their own accord and not have to wait for an employee complaint. I think it shows a trend with regard to this type of action, retaliation. Actions, whistleblower type actions are very prevalent, and we need to make sure that we have a good complaint procedure where we don't retaliate against people because they complain, and we also investigate that complaint and resolve it. That's a big takeaway here on the retaliation. So just quickly through these slides, at-will employment relationship is the kind of employment relationship that we want to have that allows us contractually to terminate the employment relationship with or without notice and with or without cause. We want to make sure that we don't breach that. In the context of the contractual relationship, any type of progressive discipline policies or promises of assurance of job security can change that employment relationship, change the at-will nature. And so we want to make sure that our handbooks don't have progressive discipline policies. We want to make sure that our managers and supervisors aren't making promises that someone will have a job forever or a job as long as they do, everything right. We want to make sure that the promises that we're making are at will in nature. And then on top of that, we want to be sure that we don't terminate or discipline anybody for these protected classifications, these areas where we're trying to make sure that are kind of off limits in our decision-making process. And the best way to do that is to make sure that we have a legitimate business reason. This goes back to a couple of things that we've already said. We want to make sure that there's a good relationship between the reason that we're terminating something and the conduct that has occurred. That's what allows us to avoid a termination, wrongful termination action for any of these criteria. So as you discipline, as you decide to terminate, you need to make sure that you can articulate a legitimate business reason for doing it. And that goes back to your policies. That goes back to your handbook. That goes back to your basis for making the decision consistent with the practices that you have that are in your written handbook. Okay, and these are just sort of different elements of that. Having the legitimate business reason for doing so. Good documentation, consistent application of the policy, and having policies that are in writing and have that standard of conduct available. All right, let's see. Let's see if we can finish up here. Last few sections or areas that we can just touch on briefly, and if there's questions, I'll be happy to answer those as well. This area of independent contractors is a big one and continues to be a very big area. This is an effort to avoid the employment relationship by hiring contractors. And these state agencies, the workers' comp folks, the unemployment folks, the DLSC, the DFEH, all of these kind of have their own standard that they look at. But the standard has something quite in common, and it is this that you see in the highlight there. An employee is someone that we control, and a contractor is someone that we do not control. And you see this is the workers' comp test. They talk about the right to control, but you'll also see it under the unemployment laws. Employer control is a big, major portion of that. And even under the DLSC, you see down at the bottom, it maintains that control remains an important factor. So if we're controlling the worker, he's our employee, she's our employee. If we're not, then there's the possibility of being a contractor. And that's really what we need to look at. Even the FEHA folks, they look at everything, but you see there in that top paragraph, the amount of control the principal exercises over the individual is one of the primary considerations. So what is the takeaway here? The takeaway is to make sure that if you have contractors, that you set it up so that you don't control them. You don't control the manner and means by which they perform the job. If you do have contractors, you need to look at that very, very carefully. This is a recent case with taxi cab drivers that illustrates that point. We won't go into that because of time. But it illustrates that the law is still, it's a very recent case from 2017, where a contractor was found to be an employee because the employer was controlling. All right, last couple of sections here. Arbitration agreements, we think, are a strong way to protect yourself against employment lawsuits. And there's some new areas here, but the takeaway is that I think that everyone should seriously consider having an arbitration agreement. And arbitration just means you're not in front of a jury, you're not in front of a judge. You get to hire a usually retired judge to do a private system of resolving a complaint. So if an employee brings a wrongful termination action, a discrimination action, a wage and hour action, then instead of going through the court systems, they go through before an arbitrator. It's more private, more fair process for the employer, and usually takes less time and less money. And that's why we recommend it. There's a lot of legal issues occurring with regard to arbitration agreements. This is about a case before the United States Supreme Court. But in general, arbitration agreements are enforceable if they're properly written, and we think that will bear out in all of the state and federal courts, even though there's a lot of upheaval right now. PAGA that we talked about a little bit before, those cases in California cannot be arbitrated. But what will happen is the court will set it aside, let you arbitrate all of the other claims, and then if there's some violations, then you can come back and have the PAGA claim in front of the court. So even in this area where you can't have arbitration, arbitration can still be an effective means. And there's a lot of confusion going on in the federal and state court systems, but in general, arbitration agreements are going to be the best way to go. If any of you are unionized, arbitration is available there as well. And if you write it properly, a collective bargaining agreement can be an arbitration agreement for all claims, not just claims under the bargaining agreement. So that's worth looking at as well. This case is just a quick reminder for lawyers more than anything else that if you have an arbitration agreement, you got to let everybody know about it early, because you can waive your arbitration agreement if you wait too long through the court system. So just a reminder that if we have arbitration agreements, we need to enforce them early on. Lastly is the National Labor Relations Board. This is the board federally that oversees union organizing. And there's been a lot of changes here with actually the new president, and he's brought in a lot of folks. But quite simply, in the past, there has been an attack on employee handbooks, and that employee handbooks are going too far. And these cases are really scaling that back. And so what it means to me in this context is that our employee handbooks, they need to be carefully drafted, but they are a great document to protect against employment actions, notwithstanding the fact the National Labor Relations Board has made some efforts to try to diminish the effect of handbooks. Handbooks remain a very, very strong way to protect your interests as an employer. All right, so that is going to get us through. Let me see if I can go back and answer some of these questions that we have now. Thank you again, Jenna, for making sure that we were staying on task properly. Okay, this looks like this question is going back to the area of the background checks and how we can use them. That seemed to be a big area that we wanted to talk about. So, yeah, the question here is, what if the applicant has multiple DUIs, and the past employees with multiple DUIs have a higher likelihood of problems getting to work due to the not being able to get to work. So I think that would not necessarily be. Now, if they were driving for work, then definitely that would be appropriate. Multiple DUIs would prevent someone potentially from having a license, and that would be an appropriate basis. But the commute time, remember, is not work time. And they can take the bus, they can have someone drop them off, they can ride a bike, whatever. So I don't think that would be sufficient. Just because someone has a DUI, you would not be able to say, well, they can't get to work. And I don't think that would be a legitimate basis under the new law to not hire. Okay, let's look and see if we've got another question here. I guess the main question is, can you use past experience in managing employees with similar criminal history to withdraw an offer of employment based on situations of the past employees? Yeah, I don't think that our past experience is going to be enough. That would be a starting point, but I think you're going to have to show a little bit more about the terms and conditions of employment, or better said, maybe the job duties of the employees that you're talking about, and some close connection, some close relationship with the criminal history. Just because we've had problems with people who, let's take domestic violence, for example. You've got domestic violence in your criminal history. We've had problems with people with domestic violence. Then that, you'd say, well, then I don't want to hire them. That's not going to be enough of a nexus, is what we say in the law, a connection between the two. There's not enough nexus there. But you might be able to say, what about a situation if they had some violence in the workplace in the past? That would be more connected. That would be something that you could look at. And all of this, again, is not going to be set in stone until we get some interpretation here. But the closer the connection, the closer the nexus, the better. And I think that is really what the law is trying to tell us here. So, okay, let's take a look and see what, we've got some more questions here. Does at-will employment mean we need no probation period and that we can terminate employment anytime, even after a long time employment? That's exactly right. Probationary periods are not a bad thing, but they don't really add any significant protection. Historically, a probationary period was meant to actually change the employment relationship. It comes from the union setting, and you have a probationary period of, let's say, 6 months. And during that period, they're at will, and then after that, they become subject only to termination for cause. And that's usually in the union setting. So if we're outside the union setting, then the probationary period doesn't really change anything, because our employment relationship is at will forever, right? They're always at will. And so the probationary period is fine. I think it works as kind of a marker for you to make sure that it's a good fit early on. It can have some significance from a disciplinary standpoint. I know some employers that will put someone back on a probationary period as a means of saying, hey, you're close to being terminated, almost like a final warning. Nothing wrong with that, but there should be no significant change in the employment relationship between probationary period and after probationary period. For the whole period, they should be at will employees. Great question. All right, another question. Can cell phone usage be a reason for termination if they continue to use it and we ask them specifically when they are working at our time? Sure. So what I'm understanding from that question is that the cell phone use is being done during work hours, during work time. Now, they have meal periods, they have rest periods, and they have before and after work. And we should not regulate cell phone usage during those time periods unless there's a safety issue. I mean, we could say while you're on work, that needs to be held in a locker or something like that, because we need your focus. I wouldn't have a problem with that. But presuming that they can have access to a cell phone, it's not a safety issue, then we should not regulate while they are on their meal period or rest period or before or after the shift. But while they're on shift, you can absolutely say no personal cell phone use. And if they don't do that, if they violate that policy, then you can discipline them up to termination. Absolutely. And the fact that you've had multiple conversations I think dictates that you could have more severe discipline on that for sure. Okay, next question here. Please, waiting time on property prior to shift begins and split shift in California. Okay, so I'm taking that to mean that just a general discussion about waiting time on property, and split shifts in California. So let's just a general discussion here. Waiting time in California is we can dictate when an employee can come on the premises. So without knowing a little bit more of the context, typically a good policy with regard to this waiting time on the property is to say don't report to work more than 10 minutes before, and please don't stay on the property more than 10 minutes after your shift. That's completely appropriate. There is some discussion about whether the parking lot is actually a part of the workplace, and in most situations it is not. So someone might be able to hang out on the parking lot, but the workplace proper, we can definitely have rules that say that you can't be on the premises more than 10 minutes before, more than 10 minutes after your shift. There's a lot of reasons for that. Union organizing sometimes is one of those. Other is safety. Another is distraction. So there's lots of legitimate reasons for limiting the amount of time that someone is on the premises. A split shift occurs. That's a little bit different. A split shift occurs when we release someone from work, but they have another shift that's coming up in the same workday, and it's further away than a normal meal period. So let's say, for example, if I have a shift that ends at noon and I have to come back at 1 o'clock or maybe even 2 o'clock, I wouldn't consider that a split shift. You could say that's a meal period. But when you get beyond kind of a couple of hours, 3, 4, 5 hours where they have to come back, that becomes a split shift. And there's a premium that has to be paid for that. It's not a difficult premium to meet typically, but it's an additional hour at minimum wage. So if this is an area where if your compensation is such that you're already making more than the minimum wage, sometimes that split shift differential, that split shift premium is already covered by the compensation already. But if you have employees who are working at minimum wage and you have a split shift where they've got that break that's more than a normal meal period, then they would be entitled to an additional hour of pay at the minimum wage. Okay, that takes care of split shifts and waiting time. Let's see, that looks like that's all of our. Oh, another question. Excellent. If an employee has facial hair and has been employed for a year, can I change the policy to no facial hair? Sure. Again, going back and making sure that we're not dealing with any protected classification. So from a religious standpoint, we'd need to make accommodation there. If it had to do with any sort of ethnicity or racial issues or anything along those lines, if it was required for medical purposes, things of that nature, then we would need to give an accommodation. But you can absolutely say we want a professional look in my workplace, and having facial hair in and of itself is not a protected classification. So that is not something that would be given special consideration unless it was tied to a protected classification. And actually facial hair has come up in cases before, but it needs to be tied to the protected classification. In and of itself, it is not protected. Okay.
Okay, Trevor. So everyone, we've already gone 10 minutes over, and I know everyone has a lot of questions. So Trevor, do you mind just sharing your email with people, and people can jump on and send you an email if they have any questions and want clarification on anything?
Yeah, can I I'll just put it in the chat. Is that okay?
Yeah, that works for me.
Let me just, I'll tell you what, it's T Hodson, THODSON, at pkwhlaw.com. And I'll just send that out to everyone. And so it's T Hodson, THODSON, at pkwhlaw.com. Feel free to email me. Just note that you're from the seminar, and I'll be happy to answer any questions that I can in the next little while here. Okay?
Perfect. Thank you so much, Trevor, for your time, and thank you everyone for attending. I think this was a really great webinar and people got a lot of information from it. Thank you, everyone.
Okay, thank you.